One.
This Honorable Court of Appeals is now in session.
Good afternoon and welcome to the afternoon session of the Court of Appeals. Your panel today will be Judge Armstrong, Judge McGee, and I'm Judge Golden. Madam Clerk, do we have anything we need to address before we proceed?
No, Your Honor.
You may call the case.
John Lynn versus Penske Truck Leasing Company, LP.
Mr. Bailey,
Yes, sir.
are you ready?
I'm ready. Yes.
All right, you're on.
Well, actually, I think I have the pleasure of being the appellee in this case.
I beg your pardon.
That is correct.
my error, you might say, Mr. LeBaire.
Thank you, Your Honor. I'll go ahead. Good afternoon, Your Honors. May it please the court. My name is Harry LeBaire, and I represent the appellant, Penske Truck Leasing in this case. We're here today on Penske's appeal of the trial court's suggested additure of $685,351 to a deliberated jury verdict of $615,000.
Mr. Blair, let me ask you just a preliminary question. I don't want to take up much of your time. When we were looking at the record, we couldn't find an actual judgment which included the original verdict plus the additor, and which included your acceptance under protest. And I saw the order on the plaintiff's motion for a new trial, but I think the statute requires there to be a separate judgment that includes the entire amount, including the additor. Is there such a pleading file?
I don't know that there is such a pleading. The only orders I'm aware of are the actual judgment that was absent, the original judgment of the jury that was entered by the court. Then several months later, an order from the court suggesting the additure, which I accepted under protest. Then again, an order on the plaintiff's motion, I guess, for clarification, again, with another acceptance under protest due to a mathematical error of the court. I'm not aware of an actual judgment being entered on the additure.
I think we're going to we'll issue an order requiring that to be filed, and y'all can get that taken care of.
Okay.
Go ahead.
The trial court's suggested additure should be reversed because it was based on a disagreement with the weight of the evidence supporting Penske's superseding cause defense, as opposed to mere dissatisfaction regarding the adequacy of the damages to compensate the appellee. In addition, the trial court's unprecedented additure of over 110% to this six-figure verdict completely destroyed that verdict. I know Your Honors have been thoroughly briefed on the facts and procedural history of this case, so very briefly, this case arises from a motor vehicle accident that occurred on May 9th, 2017 here in Memphis, Tennessee. On that day, a Penske box truck operated by a Penske employee, Carl Myers, rear-ended a vehicle operated by Andrea Ray, which in turn rear-ended a Shelby County Sheriff's cruiser operated by the appellee. Not much damage was done to the cruiser, but there was very clearly damage done to the appellee. Again, Your Honors have been briefed on the medical history, which is very, very lengthy. So I'll be very brief in that. Appellee's initial presentation with Dr. Leventhal involved spine pain all the way from his neck down to his lumbar spine with referred, not radiating, but referred pain into his thigh and buttocks. The neck and thoracic pain appears to have resolved, as did the referred pain. However, the lumbar pain persisted. In fact, and this is very important to remember, Penske has never asserted that appellee fully recovered from that initial injury. We have only ever argued that appellee sustained a treatable, recoverable injury, as demonstrated by the obvious progress appellee made and reported to his physicians once he was finally put into physical therapy a year after this accident. And that leads us to another point it's very, very important to remember when reviewing this case. Penske has never, ever suggested that physical therapy completely cured the appellee. Appellee himself suggested this in response to the only time he was ever asked why he discontinued such obviously beneficial treatment. But Penske has never suggested anything other than that physical therapy was and continued to be an effective treatment for Appellee's pain at the time he discontinued it. After discontinuing therapy, Appellee, who was back at work by this time, doesn't seek medical care for 3 months, at least as far as we know, until he shows up at the ER in December of 2018 with a supposed flare-up in his lower back pain. However, what Appellee didn't report to the ER staff, Dr. Lindy or Dr. Katz, is that he got slammed into a desk by a student that he was having an altercation with at the high school he was assigned to guard. His back was slammed into a desk. He fell on the desk and the student fell on top of him. He missed time from work, and very significantly, he filed a separate and distinct on-the-job injury claim with the Shelby County government as a result of this altercation. But Appellee and his lawyers made sure not to adulterate the trial experts or Dr. Kangas or Dr. Hoyt with knowledge of this incident. What's more, a review of the medical records from this ER visit, the medical history after that visit, and the testimony of Dr. Lindy and Dr. Hoyt demonstrates a starkly different clinical picture than what we see before. He has complaints of pain radiating down both of his legs below the knees. There's diagnostic imaging showing a large bulge with nerve impingement, and his complaints are completely and entirely resistant to physical therapy where they had previously been treatable. That's it. That's the crux of Penske's main defense in this case. The jury was instructed on it, and it doesn't require expert proof. The necessary proof came from the appellee himself, his medical records, and concessions from his experts. Significantly, the jury appears to have reached this same conclusion, as the jury verdict shows a significant award for past damages and almost no award for future damages. Turning to this court's review, there are no novel issues here. The court's review is guided by the well-established Long versus Mattingly approach, which is a three-pronged analysis which requires the court to examine the trial court's reasoning for an adjusting a verdict, examine the amount of the adjustment, and review the damages proof to determine whether the evidence preponderates against the adjustment. We acknowledge that on this record, the third Mattingly step is a tough road for all of us to hoe. This court must show deference to the trial court's findings on credibility, especially in the absence of specific findings by the jury. And in this case, the trial court made a blanket statement that there were no credibility issues. Penske respectfully disagrees for the numerous reasons cited in our brief, but absent specific factual findings, it appears we are confined to plowing through the voluminous medical testimony and witness testimony in this case. Given the sheer volume of that testimony and the medical records, I think we should focus our time here on the first two Mattingly steps, which I think form the main crux of this appeal.
Is that credibility determination of some consequence when one of the doctors testified that your concern about this school injury was a red herring?
Well, Your Honor, I don't believe that Dr. Katz was referring to the school injury. His testimony was regarding a fall that occurred at the school in December of 2018, directly after which appellee went to the ER. The school injury incident, which Dr. Katz appears to have been entirely ignorant of, occurred either in somewhere between late October or 2 weeks before that ER visit. So I understand that he said it was a red herring, but respectfully, I don't think he and I were talking about the same incident.
All right, go ahead.
Thank you, Judge Golden. The primary focus of the first step is to examine the trial court's reasoning, because adjustments are only proper when the court disagrees with the amount of the verdict. Now, we fully acknowledge that the trial court showed a clear disagreement with the amount of damages on this case in her orders on several occasions, and we concede that the trial court's language concerning that dissatisfaction has passed muster before, notably in the Bonner versus Deo case. However, what the trial court said about damages and the number of times it said it doesn't really concern us. What's concerning here is the trial court's reasoning in paragraph 4 of her order, in which she suggested the adjudicator that in that paragraph, the trial court reasons that the proof supporting Penske's superseding cause defense fell short. Given the insignificant jury award for future pain and suffering, future loss and enjoyment of life, the proof obviously didn't fall short with the jury. Therefore, the only logical conclusion we can distill from this paragraph of the court's order is that the court disagreed with the jury's conclusion on causation, specifically the superseding cause defense. Contrary to the assertions in Appellee's brief, causation, as far as I can tell, constitutes two distinct elements of a negligence case that should not be conflated or confused with the damages element. Thus, it was error for the trial court to overrule the jury on this issue under Mattingly and its progeny. Turning to the second step, this adjudicature suggested by the trial court is impermissible because it totally destroyed the jury's deliberated verdict. In reviewing the case law in the briefs, I note that almost every decision in every brief on this issue tells us not to be married to the ratios and talk about the ratios too much. And then we promptly start discussing the ratios. They tell us to review the verdict as a whole, and then we turn and run to break these verdicts down into their constituent and elemental parts. I'm certainly as guilty of it as anyone else, but in my defense, all the cases, every single one of them appears to discuss ratios. So I point this out to demonstrate that Penske isn't seeking to overturn Parker versus Epstein Enterprises as stated in Appellee's brief. And indeed, Penske's not asking this court to overturn any decision. To the contrary, we're asking this court to maintain the consistency of the trend discussed by Judge Golden in the Walton case and noted in the concurrence in the Phillips case. And that trend demonstrates that while higher ratios might be applicable to smaller four-figure, small five-figure judgments, a ratio of 100% or more has never been applied to a six-figure case. And so when viewed through that prism, the suggested adjustment of the court in this case is entirely without precedent. Moving away from ratios, it's obvious from the opening statement to the closing statement in this case that the overarching issue in this case is whether this case was a six-figure or seven-figure case. The jury agreed with Penske, trial court did not. But to get there, the trial court had to erase a substantive causation defense, a defense that was sufficient to make it to trial, a defense that was sufficient to warrant a jury instruction, and a defense that obviously carried weight with the jury. I understand that the powers of the trial judge as a 13th juror are broad, but I don't think they're broad enough to erase an affirmative defense. It looks like I'm out of time.
Yeah, so you'll have your rebuttal.
I'll pick it up on my rebuttal, Your Honor.
Thank you.
Thank you.
Mr. Bailey, let me see if I can get it right this time. You're the appellee.
I am indeed, Your Honor, and good afternoon. My name is Sadler Bailey of the Shelby County Bar, and it is my honor to represent John Lynn. It looks to me like in this case that Penske is engaging in what I could only call a work of pure fiction. The arguments that they make bear no relationship whatsoever to the trial that was conducted or the record that is before you. They make statements along the lines of that the trial judge disagreed with the jury about causation, or the trial judge obviously disagreed with the jury's obvious finding about superseding cause. And I would say to you, those things that Penske wants to call obvious are only obvious to Penske, because there's not a shred of evidence in the record to support any of that. The jury didn't make any findings about causation or superseding cause. And there is not one sentence, not a word in this entire record that would support Penske's argument that Mr. Lynn's injuries occurred in October or December. The only proof in the record came through the medical testimony of the doctors that were presented by the plaintiffs. There was no one on the side of the defense to argue causation or intervening cause. Again, this court should note in reading Penske's brief that they can't cite anything because nothing exists. It's simply not there. They just made it up out of thin air. They did the same thing with their creative analysis about that this is a additor of 110%. Well, that's just simply a flawed analysis. Under Penske's way of thinking, a remediator, you could never have a remediator of greater than 100%. It would be impossible, 100%. And yet, under the way Penske wants to analyze things, then we would have additors that have withheld appellate review in multiples of that number. It's not how you do it. You simply look at the amount awarded, including the additor, and then you ask yourself what percentage of that amount is attributable to the additor. And in this case, the answer is 51%. We have cited the cases that have stood for the proposition that even though we don't use mathematical formulas, we do know that 59% has been approved by our appellate courts. We know that 75% is not appropriate, but 59% is. We asked for a lot more in our motion for additor, and Judge Higgins didn't grant it. I think maybe she protected us from asking for something that might not have met the scrutiny of this court. But at any rate, this one does. I mean, she said all the right things. She's used all the language that Long v. Mattingly says is the correct language. She's gone through the correct analysis. I noticed that Penske spent a great deal of time in their brief trying to criticize the analysis of the plaintiff's economist, which was curious to me when one considers that the trial judge didn't even adopt the opinions of the plaintiff's expert. To the contrary, in an effort to bend over backwards to be fair to the defendant, the court actually adopted the figure provided by the defense economist Parker Cashdollar. And yet they devote page after page to attacking the methodology of the plaintiff's expert, an expert that Judge Higgins did not adopt in her findings. I think the thing that at first blush caused me any concern at all about this appeal was the entry that went from 0 to 300,000. But I was reassured, Justice Golden in particular, when I looked at your opinion in the Walton case, and it happened in that case that there was actually a specific entry. It was consortium in that case that went from 0 to 300. The court, your opinion wasn't critical of that at all. You just looked at the overall totality, and you said to go from a total verdict of 300,000 to 1.3 million just totally destroyed the integrity of the verdict. The point is, there are many instances. I can look back and cite other cases for you. Let me see. The Bonner case. In the Bonner case, even though we're dealing with smaller numbers, the jury in that case only awarded medical bills. And so the trial court went in and made additions for all the other compensable elements of damages, and that withstood appellate scrutiny. That's been done in many cases. As our appellate courts have pointed out, when you're looking at the reasonableness, and by the way, the Coffey case and every other case stands for the proposition that we're supposed to treat review of additors the same way we treat a review of remediators. Sadly, in our in our system, we've got a lot more appeals of remittators than we do appeals of additors. But at any rate, the analysis is exactly the same. And so there is not anything that they can point to that Judge Higgins didn't follow the rules, not any. The editor is 51% of the verdict. She used all the correct language. We know that when the court does that, even going to, well, you know what, I've got the West versus Epiphany Salon case, a remitter of 61%, 61.8%. That was affirmed by the Court of Appeals. We know that under Adams versus Lehman, 71% was reversed. That was too much. And so we kind of have some guidance about these things. The jury obviously felt that this man had a permanent injury, a severe injury. They awarded him $136,000, I think it was, for future medical care. And yet, even though the testimony was totally unrefuted, that even if this expensive medical care works, it would only provide relief for 50 to 80% of his pain. Even though that testimony was in the record, Dr. Hoyt made that crystal clear, a Sims Murphy neurosurgeon. The jury awarded 0 for future pain and suffering. I mean, it just makes no sense. The jury made a ridiculous award of $6,000 for loss of enjoyment of life. They made awards for past pain and suffering that would have been based upon, if you broke it down annualized, it would have yielded a recovery for future pain and suffering in the millions of dollars, okay? Even in the face of testimony that he's going to have future pain and suffering, they gave no value to that. The jury, I mean, it would be no way to mess up the liability. They, after a great deal of opposition, they ultimately made the decision to accept liability. They did that shortly before trial. So this is just a damages case. And this jury just simply made some mistakes. That's exactly why Tennessee has the 13th juror rule. That's exactly why Judge Higgins did what she did. She fulfilled her role with perfection, actually. I think if there's any criticism, Judge Golden, maybe I should have followed up with a subsequent order of judgment, which I didn't do. I hope the court will see that, you know, the record is clear that although we don't call it an order of judgment, we call it an order on plaintiff's September 2020 motion to alter or amend the judgment. But it is.
We're going to give you an opportunity to get that done. So don't be.
All right. Yeah. So we'll just enter that nunc pro tunc, I would imagine, of September the 28th, 2020. So if the court has any questions for me, I'll be happy to answer. But this is not a close call. There is no appellate issue at all in this case. Penske had to basically write pure fiction to even come up with a theory to bring this matter before the Court of Appeals. The only real issue here is they don't want to pay the judgment. That's why we're all here. They can't come up with anything because the record doesn't support in any way whatsoever a single argument that they are presenting to you.
Mr. Bailey, in the cases you cited where the editor was approved by the Court of Appeals, did we have a verdict with a breakdown of the elements like we had in this case?
Yes, sir, we did.
Okay.
And at the end, when you're getting to prong 3, the analysis is we don't get concerned with the individual items. We look at the totality of the additure. Okay, that's what we look at, the totality. Now, in a case where the jury does fill out the lines of itemized damages, the court is supposed to do an analysis of those itemized damages, which Judge Higgins did in this case. But when it comes time for a court of appeals to determine whether or not the additor should be affirmed, the approach of the Court of Appeals is not to look at an individual item of damages, but rather to the totality of the final additor. And I'm out. I've said everything I can say unless the court has any questions for me.
Does anyone have any further questions? All right, thank you, Mr. Bailey.
Thank you.
Ms. LeBaire, you have 3 minutes on rebuttal.
Thank you, Your Honor. Let's start out by pointing out that a comparison with the remediature cases is misplaced. The appellee asserts that because additure and remediature cases are governed by the same legal standards, and because remediatures are nearly 60% have been sustained appellate scrutiny, that this case should warrant similar consideration. However, as Mr. Bailey pointed out, it's a mathematical impossibility for a remediature case to be reduced by more than 100%. I disagree with Mr. Bailey's, what I can only refer to as math magic, in referring to this as a 59% adjustment to the award. The numbers are clearly there. The original award was $615,000, to which the trial judge added over $683,000 in damages. Because of the mathematical impossibility of reducing an award by more than 100%, there's really no apt comparison on a ratio basis between a remediature case and an additure case. As far as Dr. Hoyt's testimony goes, I would note that he diagnosed the plaintiff with radiculopathy, which is a diagnosis that, as far as the medical records show, did not exist before the second injury, which is in the record. Addressing Mr. Bailey's assertion that this entire appeal is based on a work of fiction, I'd say that Penske didn't author paragraph 4 of the trial court's order suggesting this additure, in which she completely erased the main affirmative defense asserted by Penske. I understand that the powers of the trial judge as a 13th juror are broad, but if they are so broad as to permit a judge to weigh and rule upon the sufficiency of defense after it has been allowed to go to the jury without a judgment for JNOV, we ought to just send the Memphis juries over to 201. Lord knows they're needed over there. By taking this defense away from the jury after the fact and transforming this 6-figure verdict into a 7-figure verdict, the trial court rendered a judgment that was certainly of a different ilk than that rendered by the jury. To conclude, Penske would agree with Mr. Bailey that this case was handled in a procedurally perfect manner prior to the post-trial proceedings. Indeed, not one error has been alleged with regards to the admission of evidence in this case or the presentation of this case. Both parties have had their best day in court. Therefore, we ask this court to exercise its power under the additure statute to overturn the suggested additure, send this case back to the trial court for entry of the original jury verdict. Thank you.
Let me ask you, Mr. LeBaire, in your opening argument, you stated that you've never argued that the plaintiff has fully recovered. And then looking at the elements of the jury verdict, the jury gave a verdict for past pain and suffering at $100,000, past loss of enjoyment at $75,000, future medicals at $134,000. And then when you look at what they awarded for future pain and suffering, it's $0. But you told me in your opening argument that you say you've never argued that he fully recovered. So I don't understand how that number ends up being 0, especially when the award for future pain, for future medicals is 134. So we know this guy is going to continue to have some issues. So you would expect that there would be something for future pain and suffering, and also some award more than 6,000 for future loss of enjoyment. I mean, are those awards, those particular elements, are they consistent with the other findings in this case about past and your argument, your initial argument, where you say, I've never argued that he's fully recovered?
Absolutely, they're consistent in terms of, if I can make 2 points, Judge Armstrong. First, as to the future loss of enjoyment of life and the future pain and suffering, they are consistent because we had this superseding cause that occurred before this second injury, where we see a substantial spike in pain and anatomical changes consistent with the second injury. We had an injury that was treatable by physical therapy. Mr. Lynn, Deputy Lynn, was responding positively, very positively to physical therapy. That was erased. He was robbed of the opportunity to recover when he got into the altercation with that student, which was an unforeseeable incident from Penske's standpoint. Penske had no control of, and accordingly, Penske was robbed of the benefit of Mr. Lynn's ultimate recovery. We're not saying he recovered, but he was capable of recovering. After that injury, he obviously is not. Now, the jury sheet is very obviously inconsistent in regards to awarding that future medical expense without awarding future pain and suffering and future loss of enjoyment of life. But this is ultimately a circular argument, because if I had brought a motion for remediature, which Penske decided not to do because they were willing to live with the original jury verdict and weren't happy with it, they're willing to live with it. I could have argued the same inconsistency by saying, why did they award him that expense without awarding him any significant future hedonic or parasitic damages?
Was there anything in the jury verdict form for the jury to weigh in on whether, from their review of the case, this incident at the school aggravated Mr. Lynn's condition? Was there anything on the form where they could weigh in on that at all?
There was not, Your Honor. The jury form was the standard form out of the TPI, which from my reading of it indicates that a jury is free to award some but not all of the damages on there, and that awarding of one type of damages does not necessarily compel the awarding of other types of damages. We've tried several cases, I'm sure, between everyone here and polled several jurors, and I think we all know that back in that jury room, we can't know what happens back there without putting the camera in there, but we all know there's a little bit of horse trading that goes on down there. I'm sure there were several jurors that believed in Mr. Bailey's presentation of the case, and several that believed in mine, and most likely a few that probably didn't care. So, they reach compromises just like lawyers and clients do in mediations and informal settlement negotiations. And nothing in our jurisprudence requires a jury to be actually precise or consistent in the awarding of these damages, as far as I can tell.
Thank you.
Thank you, Your Honor.
Any other questions? Thank you, gentlemen. We'll take the case under advisement and get you an written opinion as soon as possible.
And we'll get that order entered with the court.
Yeah, we'll enter an order directing you to do that in the next day or so, and then you can go ahead and get that order entered.
All right. Thank you.
Thank you.
This honorable court is in recess until 2 p.m.